Hello, my name is Tanya Chapman and this is a short case study. So the case we're going to be looking at today is the case of Smith versus Johnson, and you can find the case citation in the link below. Frances Johnson withdrew $540,000 from her bank account on the 17th of May in 2007. She deposited $270,000 into the bank account of her son Andrew Johnson, and she deposited the other $270,000 into a joint account in the name of her husband and her son, Andrew. At the time she withdrew the money, she was 82 years old, she had progressive dementia, and her son, Andrew, was her principal carer. So he lived in the house full-time caring for her. Not long after withdrawing the funds in July, Mr. Johnson died, and on that same day, Frances was taken to hospital, and thereafter she moved into aged care accommodation. In September, her daughter Karen Smith was appointed as her guardian and financial manager. And soon afterwards, Karen sought orders from the court to have the funds, the $540,000, returned to her mother. So she made that application on 2 points. First, she argued that at the time of doing the transfer, that Frances did not have the capacity to transfer the funds. Secondly, she argued that even if she did have capacity, Andrew should still be compelled to return them to his mother. So Andrew disputed the claim, and he argued on the basis of the presumption of advancement. So the presumption of advancement is where a parent transfers money or property to a child. The law presumes that they gifted it. So which means that the parent is required to prove then that they didn't intend it to be a gift. It puts them on the back foot. Now, fortunately, in this case, there was some medical records available from before the transfer and after the transfer, which is normally not the case. So we had medical records from 2006, which had Mrs. Robinson diagnosed with dementia. And then from basically around May through to June 2007, there were several doctors, nurses, and caseworker reports that indicated that Mrs. Robinson had dementia and that she was struggling to make decisions about her life and decisions about her finances. In July 2007, only 2 months after the transfer, Frances saw a geriatric specialist who said that she had severe dementia, she was unaware of her surroundings and time, and that she required a guardian or financial manager. Andrew and Karen both applied to the New South Wales Civil and Administrative Tribunal to be appointed as that financial manager. And it's interesting to note that in his application to be appointed as financial manager, Andrew admitted that his mother had dementia, that she had been deteriorating all the way up until June, and that she had more bad days than good. However, he did argue that on the day she did the transfer, she was having a good day. The court was asked to determine, firstly, did Frances Robinson have dementia, and was she so bad that she lacked the necessary capacity to do the transfer on the day? And secondly, if she did have capacity, should Andrew still be compelled to return the $540,000 to his mother? So Justice Forster of the Supreme Court said that she had, at the very least, had capacity to understand that in the broadest sense that she was signing checks, and therefore she had the capacity to do the transaction. He was then required to look at whether Andrew was required to return the funds, and what he looked at was principles of catching bargains, unconscionability, and undue influence. Catching bargains applies where one party to a transaction is at a special disadvantage because of illness, ignorance, impaired faculties, or other circumstances that affect their ability to protect their own interest. Now, the court applied this principle and found that Mrs. Robinson did have a special disadvantage and that she obtained no benefit from the transaction at all. The court also found that the principles of unconscionability applied, that Mrs. Robinson was under a special disability which affected her capacity to protect her own interest, and that special disability was known to Andrew and he took advantage of it. And the court also found that the principles of undue influence applied. And what they referred to there was that Andrew had been Mrs. Robinson's principal carer and she was dependent upon him, and that they said it would have been that it would have made it difficult for her to refuse the proposal when he put it to her. So in the end, the court ordered that Andrew was to return the funds as well as damages for losses. Now, the case didn't end there because Andrew then appealed. And he appealed stating, firstly, that his intentions were always to protect his mother's money, so he couldn't have been acting unconscionably, and also that she wasn't so dependent upon him that she couldn't have refused the proposal. The court didn't agree. They basically said, regardless of his intentions, he was aware of his mother's special disadvantage and he took advantage of it to his benefit. And secondly, they said that given her dementia, given that he was her primary carer and she was dependent upon him, and also given the relationship of love and care between them, there would have been unlikely for her to be able to refuse the proposal. Unfortunately, it still didn't end there. Andrew then applied to the High Court for leave for that decision to be dismissed. And the High Court held that any appeal would not have had sufficient prospects of success and denied his appeal. So in the end, Andrew was ordered to return the funds to his mother as well as damages for losses. So that is the case of Johnson and Smith. I hope you found it interesting, and I hope you join me for another case study.